Thank you so much for joining our webinar. It's the annual Stronger California Advocates Network Legislative Update, where we will be highlighting some really exciting priority proposals on our legislative agenda, as well as some really exciting wins that we've already celebrated in the budget, very hard-fought wins. We're going to be sharing information about bills that are heading into their final votes. And so this is perfect timing for everyone who is here today to learn about our policy priorities and then be geared up and hopefully very motivated from all of our amazing speakers to support these bills as they go into their final votes and then hopefully onto the governor. And as I think many people know, the budget advocacy never ends. So while you'll be hearing about some really incredible budget wins, there is still ongoing advocacy needed very soon. So we're hoping that everyone gets very pumped about these incredible priorities. We have a packed agenda for today. So if you have questions, please feel free to add them into the Q&A chat. We will try to touch on them as we go, but if not, we will address them in our follow-up email to all of you, along with action steps that you can take to support these priorities, a recording of the webinar, and hopefully some motivation to help our broader coalition get these policies across the finish line. So first of all, I would just want to say it's an honor to be accompanied by a group of amazing Stronger California advocacy partners whose pictures you are about to see on the screen. I'm going to introduce them each before they speak, but I encourage you to check out their organizations after the webinar. They, along with our broader Stronger California coalition, really are the reason that we're able to have this type of broad policy change, and I really feel honored to work with them. So we're going to start with some background about the Stronger California Advocates Network so that everyone is aware. We are a network of now over 60 organizations from all around the state. We have organizations that comprise our core Stronger California Roundtable, as well as a broader group of Stronger California Network supporters, and they are all listed on these slides, which luckily, there are too many to look now, but we invite you to check out all these organizations when you get the PowerPoint after the webinar. These organizations, along with a much even broader community of supporters within the general public, really are key to helping us get these policies and priorities across the finish line, and really to help us ensure that we're helping women and families and broader communities throughout the state. So thank you to all these organizations, as well as the individual supporters, many of whom are on this webinar right now. So we convened Stronger California a decade ago, and the goal was really to bring together a diverse group of organizations, some coalitions as well, working on a variety of different issues that are interrelated. And so we wanted to organize around a collective policy agenda to promote economic security and gender, racial, and economic justice. We engage collectively. So we all work as a collective from these different sectors to advance this broad policy agenda through engagement in committee hearings, mobilizations, community education, and elevating awareness on social media so that we can get broad support from the community and really ensure that legislators see that these are issues that a broad group of organizations and individuals care about and are going to be holding them accountable to. Our work is grounded in the understanding that women and families do not face barriers to economic security in silos. We confront them all at once. All of these obstacles come at families all at once, and we need a legislative agenda which addresses these interlocking obstacles in a comprehensive way. And I'm excited to say that this comprehensive approach and cross-sector approach that we have taken has really yielded some exciting successes. In our 10 years together, we've passed 50 bills and achieved over billions of dollars in budget allocations to support economic security for women and families and communities throughout the state. And so we're really excited to celebrate that milestone with you all and talk about what we are going to be up to now. So together, as I mentioned, we engage in a variety of community education and advocacy activities. Some of them are listed here, and we invite all of you to join us. So we'll be sending out ways for you to join the movement if you have not yet and become part of our collective in advancing these changes here in California, and many of which have been replicated in other states and really serve as a blueprint for what is possible at the federal level. So very quickly, we're going to go through in this presentation all of our policy priorities for 2024, which are centered around these 5 pillars. So I will kind of discuss each pillar as we go, but this really encompasses our comprehensive approach to addressing the myriad obstacles that women, families, and communities face. So we're going to start with the fair pay, job opportunities, and workplace justice pillar. We know that workers and families and communities cannot get ahead without fair pay and without justice in the workplace, and without opportunities to achieve better positions at work. So all of our priorities every year on this pillar encompass those goals. We're going to be joined by Shazi Kamali. She is a staff attorney at Legal Aid at Work. Kel O'Hara, who is a senior attorney here at Equal Rights Advocates, and I will also be presenting on this pillar. So I'm going to start with our first bill priority on this pillar that we wanted to highlight for you. And this is SB 1137. It was introduced by Senator Lola Smallwood Cuevas, and it addresses an issue that many of us have seen, especially those of us that advocate for workers and who have discrimination or harassment issues in the workplace. And what the bill will do is clarify that state anti-discrimination laws, specifically the Fair Employment and Housing Act, the Unruh Civil Rights Act, and the Education Code, which has its own anti-discrimination protections for students, it will clarify that intersectionality applies, that an individual can experience discrimination or harassment based on one protected class, but also can experience discrimination or harassment based on 2 or more protected classes, kind of the combination or intersection thereof. And this is already in the law, but we have seen that courts and juries sometimes do not get it right. One example was a case where Asian women professors had brought a discrimination in promotions claim, and the court originally, lower court, found that because Asian men and white women had been promoted, that defeated the claim. The Ninth Circuit appropriately reversed and found that Asian women experienced discrimination at a different type, of a unique type, because of the intersection of both their gender and their race. And that applies for other intersections of protected classes, such as gender and age, or race and LGBTQI status. So we're hopeful that this bill will ensure and make it clear for juries and courts and other decision makers that intersectionality is protected under our laws, and make it recognized under these types of cases for this type of harm. So we'll be awaiting now an assembly floor vote, and like all of our bills, you'll be hearing about ways you can support it in its next vote. I will turn it to Shazi.
Thanks, Jess. Hi, everyone. Thank you for joining us. I have to hop off right after this, but if you have any questions, you can feel free to email me or reach out to Jess or Katie, and they can pass along any questions you have. So I'm going to talk to you about SB 1022, Skinner's bill, which is about California Civil Rights Department enforcement. So just some background. If you have a claim of employment or housing discrimination and you want to bring that in court, you first have to file with the California Civil Rights Department. If you do not do so, you will your complaint will be thrown out of court because you will have been found to have not exhausted your administrative remedies. So this is like an administrative process. And as you can imagine, they have a lot of claims that they deal with every year. It's a state agency. And SB 1022 would clarify certain deadlines applicable to individual complainants, and clarify that it does not apply to CRD actions to remedy systemic discrimination. So this would allow the agency to pause individual complaints that may be resolved by group actions that the CRD is already pursuing. This is partially because, well, this is for a few reasons, but one reason is because the CRD's timeline is set by statute. So there's strict deadlines about the time that they have to do investigations or do certain things, and this would allow the CRD to more fully rectify long-running civil rights violations and provide redress to as many victims as possible. And so far, it's passed Senate and Assembly Appropriations and Judiciary, and it is awaiting the Assembly floor vote.
Great, and we're going to turn to Kel next.
That's me. Hi, everyone. I'll wait for my slide to pop up. So I'm talking about SB 1386. This is authored by Senator Caballero, co-sponsored by us here at Equal Rights Advocates and the Consumer Attorneys of California. And this bill would clarify that evidence of a survivor's unrelated sexual assault or sexual history may not be brought in to impeach their testimony as to consent or resulting harm under California's Civil Rape Shield law. Just some background, like why does this matter? Rape shield laws exist in the majority of states and at the federal level, and they're designed to protect survivors from further victimization by limiting the admissibility of a survivor's sexual history in court proceedings related to things like sexual assault, sexual harassment, sexual battery. And this is because the legal system is often traumatizing for survivors, and the types of questions that survivors can be subject to can add to the trauma that they originally experienced and compound the trauma of that original experience. We work with survivors a lot here at ARA, and we really see that many survivors are afraid of coming forward because they're afraid of their personal lives being put on trial if they attempt to seek justice. And this isn't unfounded. We do see that coming forward opens the door to harassing cross-examination, to survivors really being asked to defend the choices that they've made in their lives that are unrelated to the case at hand. I've seen this in my own clients, we've seen it in other clients. And so we've had a civil rape shield designed to address this in California for a long time now. Our civil rape shield was originally enacted in 1985. And when the legislature enacted that rape shield, they noted that prior sexual conduct evidence is more often harassing and prejudicial to the survivor than genuinely probative. Even with all this being true, in 2023, there was a new Supreme Court decision, Doe v. Mountain View School District, that basically held, the holding was such that it created a potential gap in the civil rape shield law that effectively allows defendants to blame survivors' other consensual or non-consensual sexual experiences for the harm caused by the sexual violence at issue. And the Supreme Court's analysis in that case was really based on the statutory construction of the evidence code section where our civil rape shield is contained. And so we need to clarify that and make sure that this decision that is inconsistent with legislative intent is not what is controlling, because this would have a real chilling effect on survivors. So this bill would amend the relevant parts of the evidence code section and clarify that separate sexual history evidence may only be used to impeach a survivor's testimony as to something other than consent or lack of harm. We've had a lot of success on this bill so far. It's already passed the Senate and Assembly Judiciary, and we're currently awaiting our Assembly floor vote. Thanks so much. I will pass to the next person.
Thanks, Kel. So the next pillar that I want to introduce is advancing access to affordable, quality childcare. And we are thrilled to have Jennifer Greppy, who is the statewide organizer of Parent Voices California, who is an incredible advocate for childcare, and with us today to talk about a really exciting win in the budget this year. So Jennifer, I'll pass it to you.
Hey everyone, good afternoon. So excited to be here with you all today and to talk a little bit about childcare. I'm Jennifer Greppy, and I'm the Director of Parent Policy here at Parent Voices California. And, this year's budget was a real challenging one, right? Like we were looking at some real significant cuts to many of the programs that we all love and care about. And, we here, at Parent Voices really believe that we shouldn't be balancing the budget on the backs of the most vulnerable families in California. And so we wanted to make sure that we really brought those voices of those families to the state capitol to really express why, saving childcare spaces and investing in early care and education is so important to their families. And so, the governor back in 2019 dedicated, 200,000 new spaces for childcare. And, that seems like a lot, right? It's a lot of spaces for kids, but we have over 2 million kids that are eligible and waiting in California. And so while 200,000 is important and it's a good first step, we also just want to make it clear that we still have a long way to go, a lot of work to do. And so in this budget, back in January, the governor was saying, we're going to eliminate about 11,000 center spaces, and we're going to pause any new spaces towards our 200,000 goal. And families came out in droves and really told their stories about what it's like to have their little one, at home with their backpacks on and wanting to go to school and wanting to go be with friends and to learn and grow and develop in their early childhood programs, but there's just no spaces available for them. And so they are at home, right? And we know that kids are learning anywhere they are, but we really want them to be in a place where they can get that quality early learning that they need and deserve. And so that their families, their moms, their dads can go and work and go to school and do the things that they need to do to move their families forward. And so in the end, after lots of advocating, we were able to save those 11,000 spaces for what we call CCTR, which is a center-based program space. And we were also able to sort of maintain the governor and legislature's 2021 commitment to expand childcare access to those 200,000 spaces. Although, they had promised that would happen by 25-26 budget, and now we're at the 28 budget, but it's going to happen. And so that's, a really important commitment that they've made. They've found the money to do that, and we will make it to those 200,000 spaces so that more families can access childcare. In addition to that, we also are working with providers and CCPU, the Child Care Union, to figure out a new way to pay childcare providers in California. For so long, the cost of childcare and what we're paying childcare providers has been unequal, right? And so we're looking at how can we pay providers what the true cost of care is. And we just put it in the chat for you all, but there's a really great video that CCPU put out, and you're going to click the link, and then you're going to push the little yellow button to watch the video. And it's going to explain a little bit more about what this cost of care model is. But basically, it's to make sure that we are paying providers what it costs to actually provide the care that they're providing and for them to make a living wage. And so we're really excited about that moving forward. The budget did include language to help move us towards that cost of care model. And you can also read our full budget response by going to the link in the chat. And, kids and childcare are so critical and important to all of us and to our communities and to our ability to move forward. And we're going to keep fighting until all families are served. Thanks so much.
Thank you, Jennifer. I know that many of us who've experienced the cost of childcare understand the important advocacy of parent voices and all the Stronger California partners that supported this win, and really appreciate the well-rounded approach that we take in this state of not just advocating for the lower income families to be able to afford childcare, but also for the providers who themselves are often low income, often women of color, to ensure that they are being paid a fair wage for this critical work they provide. Thank you. I'm going to now turn us to our third pillar, which is to support family-friendly workplaces. And we are going to hear from Katie Duberg. She is the Political Organizing Director for the California Work and Family Coalition, and Katie Witchett, who is a Senior Staff Attorney at Legal Aid at Work. I'll turn it to Katie.
Thanks, Jessica. So the first bill I'm going to speak about is Assembly Bill 518, which is authored by Assemblymember Wicks, Paid Family Leave for Chosen Family. So our paid leave program, or paid family leave program in California, allows us to receive partial pay from paid family leave when we need leave from work to care for a seriously ill family member. However, you can only use paid family leave right now to care for a certain list of family members that's actually listed out in the program, and that leaves out chosen or extended family. So if you need to care for your unmarried partner or your best friend who's become like family to you, or your aunt or your cousin or someone who's not on that list, you actually currently are not able to receive paid family leave. So that's what this bill aims to do. AB 518 would update the definition of family member for California's paid family leave program so that qualifying workers would be able to receive paid family leave benefits when they need to care for a member of their chosen or extended family. It's really important to note that paid family leave is 100% funded by California workers. So employees in California, we pay into the program, and then when we have a qualifying need for leave, we can receive partial pay. But right now, not all workers' families are recognized in paid family leave. So this is a really important change to ensure equity and access to the program, especially for LGBTQ families and individuals, immigrant communities, and older adults, all of whom are more likely to rely on chosen and extended family for care. I just also want to note that this is not a new concept in California law, thanks to AB 1041, which was also authored by Assemblymember Wicks and was also a stronger California priority. California workers can already use paid sick leave and job protected leave under the California Family Rights Act to care for a member of their chosen or extended family. Next slide, please. And the second bill I'm here to talk about is Assembly Bill 2901, authored by Assemblymember Aguiar Curry, Pregnancy Leave for Educators. So AB 2901 would grant school employees up to 14 weeks of leave with full pay when they need leave because they are experiencing or have experienced pregnancy, miscarriage, childbirth, termination of pregnancy, or recovery from those conditions. This is important because California school employees currently cannot earn paid pregnancy leave. And so when they get pregnant, first they have to exhaust their accrued sick leave, and then they can receive partial pay. And that partial pay is the amount that's left over after their substitute has been paid. So this means that a lot of times people are trying to schedule pregnancy over summer break or are having to forgo a significant amount of pay if they need leave. I'm sure no one will be surprised that more than 3/4 of educators are women. So this is a really important workplace equity issue, and improving pregnancy leave will help retain teachers and educators during a historic shortage of workers who are choosing public education for their career. And I will pass to Katie Widget.
Thanks, Katie. So I'm going to talk about AB 2499 by Assemblymember Pilar Schiappo, which is a bill to improve safe leave in California. So as background, we are lucky that our state does have some protections for people who experience domestic violence, sexual assault, stalking, or other forms of violence, and that there are situations where they can take time off from work to secure their safety, also to seek medical attention or engage in safety planning or to move for their safety. And they're also able to get accommodations or changes at work so that they can work and continue to be safe. So while this is important and it's we're lucky to have it as a protection, unfortunately, it doesn't really cover what we need. And that's what AB 2499 steps in to do. So first, and very importantly, it recognizes the role of family in making sure that people are able to be safe. So somebody who's moving out of a home where they're being abused, that could be a very difficult thing. And what AB 2499 does is it allows family members to also access leave so that they can assist their loved one in achieving safety and in recovering from what they've experienced. And importantly, it also recognizes that those family members of people who experience direct violence, they might also have their own needs related to recovery. So for instance, a witness who's testified on behalf of the bill, who's with Alliance for Safety and Justice, has shared how, unfortunately, after her son was killed in his home, she needed to take time off from work to help find new childcare for her grandchildren. And then she needed to help the family move from that apartment because they didn't feel safe there anymore. And so those things aren't currently covered under California law, or at least they aren't clearly covered. So this bill allows family members to take leave. It also allows more survivors to access safety accommodations at work. So people who experience violence and threats of violence, as well as family members of survivors, to ask for changes at their work to help make sure that they can be safe. And then finally, a critical change that it makes is it moves these protections from the Labor Code into the Fair Employment and Housing Act, which is enforced by the Civil Rights Department. And that can sound kind of jargony, but the Civil Rights Department is the agency that enforces most leave protections. And it's also the agency that's centrally in charge of enforcing laws against like sex harassment and sex assault at work. So as it stands, there's a lot of people who either have to file with both agencies that have different timelines and different processes, which can be really confusing, or they just have a hard time asserting their rights through the labor commissioner's process. So by moving these to one place where workers will have more opportunity to assert those rights without going through multiple different processes, hopefully it'll make it more possible for people to feel like they have these rights and they can use them and they don't have to worry about losing their job or being retaliated against or not having an option if something goes wrong. So that is AB 2499, and I'll pass it back to Jess.
Thank you, Katie. And, you know, we in the Stronger California Network prioritize passing these really robust policies and protections, but also ensuring that they are not just written on paper, but that the communities and people to whom they are directed and who need them most are aware of their rights under these laws that we help pass, and also that they are actually able to utilize them and obtain the protections that we hope they would. And so really appreciate that presentation, Katie. And again, we'll circulate ways for everyone to support this and our other bills. So we're going to move on to the next pillar. This pillar focuses on building economic security by addressing and combating poverty, but also building assets. And so we recognize the need to ensure that we have a very strong safety net. And even in times of large budget deficits, which I know you'll hear more about in a moment, where it can be very hard to maintain these safety nets, we fight even more so and even harder to maintain these protections, and then also to pass new laws that will help people to actually build assets and try to get out of poverty. So we will be hearing from Andrew Chan, who is the Managing Director of Public Policy at Grace End Child Poverty California. Krista Colon, she is the Public Policy Director at the California Partnership to End Domestic Violence. Jassy Grewal, who is the Legislative Director at the UFCW Western States Council, and Amy Holm, Public Policy Co-Chair at the American Association of University Women of California. So I will turn it to you, Andrew.
Thanks, Jess. And thank you so much for being here. We at Grace End Child Poverty California are so glad to be a part of Stronger California. And we know there's a lot of overlap between the groups, and really appreciate that stronger together mentality. So I'm focusing on the CalWORKs budget, but maybe just a very brief nod to what Jessica teed up, which is that there really were significant cuts threatened across the safety net. And that I think just speaks to the broad asset building and anti-poverty pillar. And so that included CalWORKs, but it also included childcare, which Jennifer spoke to, foster youth, IHSS, and other programs, many of which support women directly or households that are disproportionately led by low-income women, and often low-income women of color. And that is certainly the case for CalWORKs. And so I'm very excited to share that more or less across the board, and we can get into details later and in follow-up, but it's the case for CalWORKs and essentially all of the safety net programs, that while there were some cuts to utilization levels, meaning that if not all the money in a program was being spent, there was a cut down to the expenditure level. But as many of you know, there were proposals to zero out the budget for a significant number of programs, including several just within CalWORKs. And thanks to the leadership of the legislature and the partnership with the governor and administration, there was an agreement to prevent those cuts and to sustain those programs, even if there are temporary reductions in the funding levels. And I don't take those funding reductions lightly. They may mean in the real world that there will be some denial of access and services for the next 2 years over the course of this agreement. But compared to what was proposed, they really are significant wins, and they wouldn't have happened without community. So I've named some of these here. These are just within CalWORKs. Intensive case management, so the hours needed for the counties to support families with the most barriers. There was a proposed increase in those hours. That was not agreed to, and so they're held constant. And then for subsidized employment, which makes sure that there are job opportunities, many of which are actually at county welfare offices. And there was some beautiful cross-sector advocacy with SEIU members. You're seeing some images of that there on the right, where not only were families talking about how important these services were, but workers were talking about how they had been on the program, they'd been on aid, and then had become a county welfare worker. And just think of that transformational opportunity to have culture change within the program, and a program we know is so heavily stigmatized, but to have workers who actually were on aid now on the other side of that conversation. So subsidized employment was sustained at utilization levels, as was mental health and substance abuse, which there were some very crazy conversations about Prop 1 and like Medi-Cal and other ways to fund these services. And so really important work to protect the particular CalWORKs services needed for mental health and substance abuse. As so many families who are already experiencing systemic racism, patriarchy, and poverty are experiencing. And unfortunately, the other issue with the budget is that it withdraws all of the safety net reserve over the 2-year period. And unfortunately, there is only a very small reserve dedicated to Medi-Cal and CalWORKs that's really meant to recognize the fact that, especially what we saw in the Great Recession, was that when there is like a sort of normal recession, which we know this past year has not been, but during hard times, right, there is an increased need for safety net services at the same time that revenues go down, right? And it's that gap where the safety net reserve was created. And so while the programs were largely protected and preserved, they are now more exposed to potential future cuts if the revenues don't rebound. And so I want people to keep an eye on that, because that is something that we are all going to be returning to, trying to replenish that reserve and make sure that we have some cushion, particularly for the safety net. And if you're not sort of tracking this issue, the Cal Budget Center put out a good summary, and they talk about how the much larger rainy day fund and the education stabilization accounts, which are much larger, were not fully tapped. And there was a more prudent use to save some of those reserves, but that was not the case for safety net reserve. So some of the best news is that there is a pot of funds for the Department of Social Services to pursue these national pilots that are very much in line with the community goals to reimagine CalWORKs. Again, you're seeing some of the family energy on the right. Huge thanks to Parent Voices, to the student parents that are reimagining CalWORKs, a lot of the college students who are pushing that. And so there's going to be much more to do. The application is already going to be due in a month. I hope folks can follow up with me if you'd like to dig in further on that. A marker that there is trailer bill language that requires the Department of Social Services to actually come back and provide detailed policy and fiscal technical assistance to the legislature and to advocates. And so while we didn't win the reforms we were looking for this year, again, we had to spend most of the year focused on defeating the cuts. We expect some very detailed and actionable information. So big things on the horizon for the Reimagine CalWORKs Coalition, and we'd love to include more of you in that. And then last and certainly not least, the budget ends what's called comparable disqualification, meaning that if you had a sanction in CalWORKs, which many of you know is one of the core things we're trying to address, we had a comparable sanction in CalFresh, which we absolutely did not have to have. And this meant that the poorest families, which are 90% of which are led by either Black or Latina mothers, had a double sanction, taking your cash in CalWORKs and your food in CalFresh. And so at least the comparable CalFresh sanction has been taken away. And this is one of the original End Child Poverty California recommendations. So we're really excited and grateful to all the legal aid attorneys who helped lead that. And I think it's already in the chat, you can see our full response that really celebrates that while this budget was far from perfect, it's the first time that the safety net has been preserved instead of seeing dramatic cuts going back to Ronald Reagan as governor. And so we really are excited about that, and want to build on this for the future. Thank you.
Thank you, Andrew. I just wanted to thank you for your work and also just really emphasize how incredible it is to be part of a movement to try to fend off, and successfully in this case, fend off cuts during one of the worst budget contexts we've seen. And especially with this history of balancing the budget on the backs of the lowest income people in California, but at the same time, really maintaining momentum to have a real future goal of ensuring that the CalWORKs program itself is completely restructured and to eliminate these just really punitive and unfair provisions. And Stronger California, as a coalition led by Grace End Child Poverty, Western Center, and other groups within our membership, has already addressed some of those really punitive aspects of CalWORKs, such as eliminating the maximum family grant rule, which just unfairly penalized low-income families, and really appreciate that dual focus of keeping the funds that we need and also reimagining the program to better serve people and families. Thank you, Andrew. I'll turn it to Krista.
Thank you, Jess. And I just want to name, before I jump into the specifics of this budget item, how closely connected all of our work is, right? So I work at the California Partnership to End Domestic Violence on behalf of domestic violence service providers and the survivors they serve. But those programs, the survivors, don't rely just on funding that's dedicated to domestic violence. CalWORKs is a vital resource for the families that are seeking services. Childcare makes the world go round, right? I would not be here right now if my baby could not be in childcare, but for every parent who is fleeing a violent situation and needs to be able to go to work and relies on childcare to be able to do so, those wins are so important. And so I'm so grateful for the colleagues that I have through this coalition and to Stronger California to bring us all together. So this specific item relates to crime victim services. And this is actually an issue that has been emerging because of reductions in federal funding for crime victim services through a particular funding source known as the Victims of Crime Act. And I see that there's already a link in chat, so you can read more about that. But ultimately, what this meant for the state budget is that victim service providers, including domestic violence shelters, rape crisis programs, child abuse advocacy centers, legal services, human trafficking, the victim witness programs at the DA's office, and on, about 380 victim service providers were facing really massive budget cuts. And so we had to ask the state to step in with hundreds of millions of dollars in essentially new money. These are not dollars that exist in the state budget. They rely on the federal funds for this. And so in the midst of this terrible budget year, we were asking the state to find up to $200 million in new dollars to spend, which is a remarkable thing to try to do. We were incredibly lucky that this had really bipartisan support. Assemblymember Reyes was our huge champion. Over half the assembly signed on. The legislature actually included $103 million in ongoing funding in their proposal. And in the final negotiations, we ended up with one-time money. So we have been able to keep these victim services stable for this fiscal year. We're already talking about 2025 and planning for that, and you all will be hearing from us. And then we also have a bill pending, AB 2432, currently in Senate Appropriations, but that would establish a new state-level funding stream for victim services through fees assessed on corporations that are convicted of crimes. And that would create a new victim services funding source. But that's a long-term solution that's going to take time to come into effect. So we really need everyone's support for that bill, but also need to continue to stabilize victim services so that every time survivors are reaching out for help, calling a hotline, seeking housing, that someone is there to answer that call. And so we'll be continuing to work on the next few budget cycles until we can find permanent stability between federal and state level funding. Jess, I think I can hand it back to you.
Thank you. We can go on to the next slide.
Hi, everyone. My name is Jassy Graywall. I'm with the United Food and Commercial Workers Western States Council. And just want to say thanks to Andrew and Krista for the important work that they do for this pillar within the Stronger California Network. We're going to switch gears just a little bit to focus on food insecurity and the work that we're doing in this space this year. AB 1961, known as the End Hunger in California Act, authored by Assemblymember Wicks, establishes a task force that for the first time in state history will develop a strategic master plan to end hunger in California. The task force will include food system stakeholders who will collaborate at the local, regional, and state levels and in partnership with tribal governments on ways to remove barriers to access adequate, nutritious, and culturally appropriate food for all communities in California. California is the 5th largest food supplier, producing nearly half of the nation's fruits and vegetables. However, more than 1 in 5 Californians, about 8.8 million people, currently struggle with food insecurity. Hunger and lack of access to nutritious food are exacerbated by racial and economic inequalities, with 40% of Black households and 30% of Latino households being food insecure in California. And these numbers are often very underreported. And so just know that this is oftentimes an undercount of the true food insecurity needs that Californians face. Food deserts are regions in the country where at least 1/3 of the area's population is living more than a half a mile away from the closest supermarket or large grocery store, and a large proportion of households are low income, have inadequate access to transportation, and a limited number of food retailers providing fresh produce and healthy groceries for affordable prices. In 2021, 65% of San Francisco and San Jose metro area neighborhoods were considered food deserts, and in Fresno, over 20% of the residents live in food deserts. Sadly ironic, the workers who grow and deliver food face higher levels of food insecurity than the rest of the U.S. workforce. Even though food surrounds grocery workers, over 3/4 of Kroger grocery workers are food insecure themselves. Food desert communities lack the resources to attract large grocery store chains, leaving residents with convenience stores and fast food restaurants as their primary food sources. According to the Human League, grocery store owners avoid opening stores in food deserts because market research suggests that more affluent areas are more profitable, and it is not just lack of access to food that is driving families to experience hunger. The cost of food has significantly increased. It has been over 30 years since food was this expensive. AB 1961, as soon to be amended, will require the California Department of Food and Ag, in partnership with the Strategic Growth Council, to establish and convene the End Hunger in California Master Plan Task Force to make recommendations for future comprehensive strategies to address access to healthy and culturally relevant food for all Californians. The task force includes representatives from the Department of Public Health, Department of Education, Department of Social Services, Governor's Office of Economic Development, and the Labor and Workforce Development Agency. It also includes stakeholders representing workers in the food sector, nonprofits with expertise in regional food systems, anti-hunger organizations, farmers, grocers, local governments, academics, and tribal representatives. A really broad and inclusive representation of our food system. The task force will assist in the development of a master plan that will be distributed to the legislature, providing maps of food deserts in California, which have not been updated since pre-pandemic times, identifying barriers for food retailers to locate in food deserts, strategies on how to increase participation and benefits received through the federal nutrition programs, recommendations from improving food access, analysis of state programs that invest in our food system, and establish milestone goals to end hunger in California. We are proud to sponsor this bill with the California Food and Farming Network, GRACE and Child Poverty California, and the California Association of Food Banks. I'm happy to answer any questions when the time is right.
Hi, everyone. I'm going to be talking to you about AB 2843, introduced by Assemblymember Cotty Petrie Norris and sponsored by AAUW California. This bill removes the issue of cost sharing as a barrier for rape survivors who otherwise would not be able to seek medical care and forensic exams through their healthcare plans. This important measure will ensure that rape survivors can access emergency medical care and forensic exams and increase the potential for identification, arrest, and conviction of sexual predators. Sexual violence is a traumatic assault perpetrated by partners, individuals known to survivors, and by strangers. Just 1/5 of survivors seek medical care following their assault. And people of color and members of the LGBTQ plus community are far less likely to seek medical care and to report their assault. Survivors choose not to report their assault for a variety of reasons, including cost, shame, distrust of law enforcement, intimate partner violence, or otherwise knowing their perpetrator, and fear of retribution. Cost presents a structural barrier for rape survivors who wish to seek medical care and those who wish to pursue charges to bring the predator to justice. This barrier also creates significant challenges to law enforcement and their ability to bring the perpetrator to justice. While forensic exams and rape kits are free, other costs associated with an ER visit are not. The average cost for an emergency room visit is approximately $3,600. Rape survivors with private insurance pay an average of $350 out of pocket. The trauma that survivors of sexual violence endure is painful and distressing enough. They should not then be sent a bill for the care they receive. AB 2843 prohibits insurers from charging rape survivors for medical services and care related to their assault. The bill requires healthcare service plans to provide coverage without cost sharing for emergency room medical care and follow-up medical treatment following a rape or sexual assault. AB 2843 ensures that those individuals who wish to report a rape and those who wish to file charges will have the benefit of a rape kit test and forensic exam to provide evidence to secure more convictions for acts of sexual violence. And most importantly, they will be able to receive the medical and health care they need following a traumatic sexual attack. Back to you, Jess.
Thank you, Amy. We're going to move on to our last pillar, and this is a pillar that we added several years back. It is protecting health and reproductive rights. And like all of our pillars, we take a comprehensive approach to the priority issues that we cover on this pillar to ensure that issues that might not always be understood to be within this realm are more broadly understood by our supporters, by legislators, and by the broader community. So I am really excited to be joined by Craig Pulsifer, who is the Legislative Director of Equality California, and Molly Robeson, who is the Vice President of Governmental Affairs for Planned Parenthood Affiliates of California, to finish us up today and tell us about the priorities on this pillar. I will turn it to Craig.
Hi, everyone. Good to be with you today. Going to talk about Senate Bill 729 by Senator Caroline Menjivar, which will expand health coverage for fertility care, including in vitro fertilization or IVF. The bill will also update the definition of infertility to be inclusive of LGBTQ people and ensure that anyone in California seeking to build a family has access to infertility care and treatment. So as many of you know, California has been a nationwide leader in safeguarding access to reproductive health care, including expanding access to abortion and contraception. But true reproductive freedom means that all people can decide if and when to start or grow a family. And this means not only having access to birth control and abortion, but also having access to fertility and infertility care. But unfortunately, the safest and most reliable methods of fertility care remain out of reach for most Californians. Under current California law, health plans are only required to offer health coverage for infertility treatment if it's requested by employers, and it actually excludes coverage of IVF from any plan. So current law does not require that plans actually provide coverage. And California is significantly behind on this issue nationally. 15 other states have already passed IVF insurance mandates. In addition, current law has invasive standards of proof to access care that don't apply to most LGBTQ couples, including needing an official medical diagnosis that could take years to achieve, and requiring folks to have completed a year of regular sexual relations without contraception. So without insurance coverage, the out-of-pocket costs for these treatments are simply insurmountable for most Californians. IVF can run anywhere from $24,000 to $38,000, depending on the clinic and whether a patient needs donor egg or sperm. So for Californians struggling with infertility, the very existence of the family they hope to build can depend on income alone. And rates of access to fertility treatments are lowest among families with low incomes, Black and Hispanic women, and LGBTQ people. So SB 729 will help to address this issue by requiring large group health plans to provide coverage for infertility treatment, including IVF. It would also update the definition of infertility to prevent discrimination against LGBTQ people by classifying people as infertile who are unable to reproduce without medical intervention, either as an individual or with their partner. So as many of you know, this bill is now more important than ever given attacks on IVF across the country. Just last month, Senate Republicans blocked a bill to protect IVF nationally, despite the fact that the majority of Republicans and Democrats across the country support IVF. So SB 729 is really an important opportunity for California to be a leader on this issue at a time when many states are becoming increasingly anti-woman, anti-choice, and anti-LGBTQ. And it's time for California to join the 15 other states that require coverage for infertility care. So this bill is currently in the Assembly Appropriations Committee. If you have any questions or would like to support the bill, please reach out to me directly. Thank you.
Thank you, Craig, for highlighting this critical issue. And I'm going to now turn it to Molly to provide the overview on our last bill that we'll be highlighting for you today.
Everyone, hi. Molly Ribson with Planned Parenthood Affiliates of California. So as you all know, the Dobbs decision, which stripped away access to abortion in states across the country, happened now 2 years ago. That decision brought abortion access and advocacy sort of to the front lines, especially in California. And since then, we've been able to pass a lot of progressive and protective policies in this space. However, one of the ongoing barriers to accessing abortion is access to a clinic with comprehensive care, even here in California. So AB 2085 remedies one of these obstacles standing in the way of access, which is onerous and subjective permitting laws that allow anti-abortion individuals, organizations, and local governments to weaponize these laws and policies to prohibit health center construction. So one example of that here in California that our affiliate is seeing firsthand, 2 years ago, the local Planned Parenthood affiliate in the city of Fontana began the process of leasing a new site to open their 4th health center in San Bernardino County, which is the largest county in the nation. The prospective site had been vacant for nearly 5 years and was already zoned to be a health clinic site. The affiliate worked closely with the Planning Commission, following all standard procedures, abiding by local guidelines, and adjusting their plans to comply with local standards, even at the smallest details like changing external light sconces. After a year of doing all of that, they received verbal approval from the head of planning commission to move forward. And then shortly thereafter receiving that, the Fontana City Council placed a temporary moratorium on any new buildings in the specific area where this prospective health center was supposed to be. After additional research, it was discovered that only that permit was being impacted by the moratorium. And shortly after that, the moratorium was extended for another 10 months. And then literally just last week, the city council extended that moratorium for another year. So the building has been rented by Planned Parenthood for 2 years. It remains, vacant, unable to provide critical care to the community, which is a community that does lack access to comprehensive care and deeply wants a clinic in that center. So the Fontana case study is just a current example of barriers that are being implemented, even in progressive California, which is a reproductive freedom state. And so we're doing AB 2085 to prohibit local interference for unjustified reasons and place a time limit on how long local jurisdictions have to make decisions related to approving or denying permitting for construction of reproductive health centers. The bill is in Senate Appropriations. I believe it's on suspense, even though it has relatively low fiscal, and it will hopefully make it to the Senate floor at the end of August.
Thank you, Molly. And I really appreciate the point for those of us who understand that we're far ahead of many states. Just a reminder that there are still these barriers in certain parts of California for those who need reproductive health care, and really appreciate the overview of this bill to address one of those barriers. We have come to the end of the presentations on our priorities as well as the wins we've already celebrated and what is to come. So just want to finish the presentation today by letting you all know or reminding you that we will be sending an email with ways to support all of these priorities going forward. As I'm sure everyone knows, it is critical that legislators and eventually the governor hear from the people in California who are affected, who care about these issues, that are using their voices to say that we need these policy reforms. So please engage as you can in the follow-up requests. We've also included a link here, and it will be in the email if you want to get regular Stronger California updates. And if your organization is interested in joining the Stronger California Advocates Network, we've included emails here for you to reach out to begin that process, as well as a QR code. I just want to close by saying that every time I hear these presentations by my colleagues within Stronger California, I'm just so energized and excited, because we really do live true to our founding principles from now a decade ago, to take a comprehensive approach and not just address the issue of economic security for women and families and communities in silos or in single issue campaigns, but rather to take a comprehensive view and a cross-sector approach with all of these great organizations and many more who are not on this webinar, but are part of the network more broadly. And so it is really, truly an honor to be a part of this. We want to thank everyone who participated today for your ongoing support, and we will look forward to getting all of these critical policies across the finish line with all of you this year. Thank you, everyone.